Swayam Prabha. Digital India. Educated India.
Good day everyone. A warm welcome to all our viewers, and I'm delighted to have you all here on this engaging and enlightening journey into the world of jurisprudence. Myself, Dr. Simranjeet Kaur, Professor and Principal, School of Law, City University, Ludhiana. In today's lecture, we will discuss Roger Cotterrell, The Politics of Jurisprudence. So, let's embark on this intellectual journey together and uncover the fascinating world of legal theory. So let's start with the topic. Roger Cotterrell, The Politics of Jurisprudence is an illuminating book at several levels. On the surface, it provides a survey of legal theory, past and present. In the course of setting out various theories, Cotterrell critically engages them, astutely pointing out gaps and weaknesses and indicating how they relate to and measure up against the competing theory, that is, standard fare for the jurisprudence text. What sets his book apart is that he does not stop with theoretical exegesis. He looks beyond the theories as well, identifying surrounding factors that influenced theorists to take particular position or focus on particular issues, and factors that help explain how contemporaries responded to these theories. Cotterrell places special emphasis on the need of the legal profession and the legal system for the legitimation. As he states, the claim that there is an important relationship between normative legal theories concerned with the unity or system in law on the one hand, and the legal professionalism and politics on the other, provides a framework in which to consider in the following chapter some influential currents of the Anglo-American legal philosophy. This angle allows Cotterrell to uncover the fascinating insights that are not immediately apparent if one examines only the substance of the theories. His framework prompts a question about the book itself. Cotterrell argues that legal theory and the legal theorists who construct them are influenced in subtle ways by their surrounding context of the creation. Presumably, this analysis applies to any work in legal theory. Cotterell's book is not just about the jurisprudence, it is a work in the jurisprudence. Insofar as he asking these questions brings to the foreground a context that runs throughout the book, which Cotterrell mentions but does not emphasize. He repeatedly exposes the various ways legal theory has served the needs and interests of the legal profession. Thus, he writes, the book suggests that this legal philosophical literature has helped to reinforce the views about the nature of law, which have seemed important for the legal professions, statutes and objectives at particular times. Legal theorists, however, have identified themselves not just with the legal profession, but also in some cases, more so with an ever high calling in their minds, developing the philosophy or science of law. This is about the pursuit of the fundamental truths about the law. Legal theorists are academics with the professional scholarly commitments and ambitions that influence their theories of law in direct and subtle way. One of the ironies of the Cotterell's argument that certain legal theories can be understood in terms of serving the interest of the legal profession is the lawyers have regularly asserted that theoretical work on law is irrelevant what they do. Their indifferences does not refute Cotterell's argument, but it evidences a divide that must be taken account of herein. I bring out how academic professional commitments have influenced legal theories, and I show how political commitments can conflict with professional commitments among the members of the legal professions. Paying attention to these other sources of influence, I suggest, helps provide a richer sense of factors that might influence theory development. Normative versus empirical legal theory. To understand Cotterell's argument, one must keep in mind the fundamental contrast he draws between the normative legal theory and empirical legal theory. Normative legal theory emphasizes the unity reason and the system in the law. Empirical legal theory sees law as a social institution that cannot be isolated and is best understood throughout the application of social sciences by its nature. Normative legal theory tends to exclude systematic consideration of the social context of law. It does so in two ways. First, unlike the empirical legal theory, which is a major concern of sociological studies of the law, normative legal theory, as it has been defined in this lecture, attempts to explain the nature of law almost exclusively through philosophical analysis and clarifications of the values, concepts, principles, rules and modes of reasonings entailed in or presupposed by the legal doctrine. Empirical legal theory, by the contrast, relies heavily on the systematic empirical analysis of the legal institution in their social environment and historical context. These behavioral and contextual inquiries are largely absent from the normative legal theory. Rather than the close of law, analytically, legal theory should interpret it in ever-widening perspective. But normative legal theory has usually been produced from the perspective of very specific kinds of the legal participants, especially lawyers. So, it has often served systematically to express rather than challenge their outlook, to confirm and refine their views of the nature of law, while being influenced by their special practical needs with regard to the ordering and interpretation of the legal knowledge, ignorance about the surrounding social factual and intention to the empirical information about the law. Cotterrell argues, render normative legal theories defective as accounts of law and less useful to the legal profession, legal system and communities. Ultimately, then the conclusion must be the normative legal theory and empirical legal theory needs to become a single enterprise. Several odd implications follow from Cotterell's dichotomy. For one, it classifies as a normative theories that the theorists themselves thought were not normative. For example, John Austin's journal Jurisprudence, which he presented as concerned with the law as it necessarily is, rather than with the law as it ought to be. Austin's theory evolved conceptual clarification aimed at capturing the nature of law. Furthermore, Cotterell's category group together theories that stand in the opposition. H.L.A. Hart's legal positivist and Ronald Dworkin's anti-positivist theories are both normative legal theories. In Cotterell's scheme, normative has a special dual meaning here. Normative legal theories, according to Cotterell, attempts to explain the nature of law as a structure of legal idea or legal doctrine, that is, in the term of unity, autonomy, rationality, moral justification or systematic character of legal doctrine. This appears to invoke normative in two distinct senses. It views law as a system of norms, and it involves an effort to portray law as a normatively worthy or legitimate. Empirical legal theories, in contrast, view law as a social institution, explain law by reference to the external social factors, and draw from the social science to provide a fully informed account of law. Cotterell identifies his dichotomy with the Hans Kelsen's distinction between normative jurisprudence and sociological jurisprudence. But there are major differences. Kelsen meant normative only in the first sense, law as a system of norms, and Kelsen presented tripartite breakdown the limits of this subject. Analytical jurisprudence and its cognition must be clearly fixed in two directions. The specific science of law, the discipline usually called jurisprudence, must be distinguished from the philosophy of justice on the one hand and from the sociology or cognition of social reality on the other. Legal positivist approach and the natural law approaches are thus placed in the separate categories. Moreover, Kelsen maintained that analytical jurisprudence and sociological jurisprudence cannot be combined. The pure theory of law by no means deny the validity of such sociological jurisprudence, but it declines to see in it, as many of its exponents do, the only science of law. Sociological jurisprudence stands side by side with the normative jurisprudence, and neither can replace the other because each deals with completely different problems. The academic influence on the legal theory. Legal theorists are the theorists, not the lawyers. They tend to have a theoretical turn of the mind attracted to abstraction, generalization, organization, systemization, categorization. They are inclined to the logic and structure, to making sense of the things, to articulating rational connections, to finding order within the apparent chaos, to creating coherence. Academic settings that support the production of legal theory value and reinforce these traits. Notice that several essential qualities Cotterell identifies with the normative legal theory, emphasizing legal unity, rationality, system, and order, are also qualities that mark theoretical work in journal. At least before the advent of the postmodernism, what Cotterell attribute to serving the interest of the legal profession, therefore, can also be understood as the inclination and type of the work theorists do. Take John Austin. He died in relative poverty and all but forgotten. Austin failed at the bar after a brief stint, and then he failed as a lecturer of jurisprudence after a few years in the professorship. When his lectures divided to the handful attendees, Austin failed as a lawyer because he lacked the aptitude for the legal practice. His widow Sarah Austin explained, but he failed as a jurisprudence professor because the demand of anything like scientific legal education had to be created. When Austin's The Province of Jurisprudence Determined was originally published in 1832, it made no apparent impact. Lord Melbourne said at the time, it was the dullest book he ever read and full of truism elaborately set forth. When politics and professional interests clash. Paying closer attention to what members of the bar say about the law and judging exposes the legal profession as not always united, and sometimes how persons' political commitments clash with the professional interest. The turn of the 20th century was a period of the great turmoil in the American society that played out in the legal arenas. At the time, courts were the target of the sharp criticism for favoring capital at the expense of the labor, for allying with the rich against the poor, and for enacting barriers against the social welfare legislation. Some members of the bar joined in these criticisms, issuing candid remarks about the social influences on judging. A remarkably modern sounding article, Politics of the Supreme Court of the United States, was published in 1893 by Walter Coles, a St. Louis lawyer, in the leading American Law Review. Coles examined Supreme Court decisions over the prior century, matching the political background of the justice with their decision, viewing the history of the Supreme Court at large, and stating conclusions somewhat broadly. It may be said that its adjudication or constitutional questions have in their journal tendencies conformed, in a greater or the lesser degree, to the magazines of the political party whose appointees have for the time being dominated the court. He criticized several Supreme Court opinions as vague, weak, incoherent, and uncandid, best explained not by the stated legal reasoning but by the political views of the judges. To say that no political prejudices have swayed the court, noted Coles with the consummate realism, is to maintain that its members have been exempt from knowing weaknesses of the human nature, and above those influences which operates most powerfully in determining the opinion of other men, especially when no clear precedent exists. He asserted a judge's conclusion will be largely controlled by the influences, opinions, and prejudices to which he happened to have been subjected. Critical commentary along these lines came not just from lawyers but from the prominent judges. Walter Clark, Chief Judge of the North Carolina Supreme Court, delivered a series of the speeches in the first decade of the new century, challenging court decisions that were antagonist to the progressive causes. It has never been charged that such judges are corruptly influenced. But the passage of the judges from the bar to the bench does not necessarily destroy his prejudices or his predilections, having spent their lives at the bar in the advocacy of the corporate claims. This will consciously but effectively be reflected in the decisions they make. Having attempted as the lawyers to persuade courts to view debated questions from the standpoint of the aggregated wealth, they often end by believing sincerely in the correctness of the such view, and not unnaturally put them in the force when in turn they themselves ascend the bench. The due process and the equal protection clauses, Clark said, are very elastic and mean whatever the court passing upon the statute think most effective for its destruction. This is of course makes of the vital importance the inquiry what are the beliefs of the majority of the court on economic question and what happens to be their opinion of the sound public policy. A power so great and so unreviewable and therefore so responsible has become the mainstay of the anti-progressive element. Another prominent legal progressive, Judge Seymour Thompson, used blunter terms when characterizing the 1895 Supreme Court invalidation of the income tax. Our judicial annals do not afford an instance of the unpatriotic subservience to the demands of the rich and powerful classes. That powerful have been encroaching through the courts, warned John Gibbons, an Illinois circuit judge. Security under the law is vouchsafed in unstinted measure to property rights, but niggardly doled out when personal right seeks redress and recognition at the bar of justice. The plea of the powerful is potent, but the plaint of the poor is too often unheard. The mighty forces of the wealth compel a hearing where the struggling ranks of the work are denied a standing in the court. What statement like these show is that legal professionals were not united behind the image of law as purely a system of norms and were willing to raise sharp questions about the legitimacy of the law. Legal practitioners and the legal academics have long been aware of the opinions of the law and how judging is sensitive to the background social views. Consider these comments by a well-known law professor, Christopher Tiedemann, uttered in 1896. If the court is to be considered a body of individuals standing far above the people, out of the reach of their passion and opinions, in an atmosphere of the cold reason, deciding every question that is brought before them according to the principle of eternal and never varying justice, then and then only may we consider the opinion of the court as the ultimate source of the law. This, however, is not real evolution of the municipal law. The bias and the peculiar views of the individual judge do certainly exert a considerable influence over the development of the law. The opinion of the court in which the reason for its judgment is set forth is the most valuable guide to a knowledge of the law on a given proposition. But we cannot obtain a reliable conception of the effect of the decision by merely reading the opinion. This, through the knowledge, is to be acquired only by studying the social and political environment of the parties and the subject matter of the suit. The present temper of the public opinion and the scope and character of the popular demand as they bear upon the particular question at issue, the mighty forces of the wealth compel a hearing where the struggling ranks of the work are denied a standing in the court. What statements like these show is that legal professionals were not united behind the image of law as purely a system of norms and were willing to raise sharp questions about the legitimacy of the law. Legal professionals and legal academics have been aware of the opinions of the law and how judging is sensitive to the background social views. This thorough knowledge is to be acquired only by studying the social and political environment of the parties and the subject matter of the suit, the present temper of the public opinion, and the scope and the character of the popular demand as they bear upon the particular question at issue. Cotterell's portrayal of normative legal theory systematic presentations of the unity of the legal doctrine that legitimates the law, suppresses the seething criticism of the law and judging that are expressed from within the legal profession and the legal academia. Cotterell mentions skepticism and realism as theoretical perspective on the law associated with the legal realist and critical legal study. That is standard jurisprudential narrative, but the above statements were uttered over generations before the emergence of the legal realism. Every generation has its own political battles played out in the law, and the losing political side will respond with skeptical criticism of judging. Legal practitioners are well aware of the realism of the law and judging. Multiple political and professional commitments can sometimes pull a legal theorist in a different directions. Roscoe was committed to law and the legal profession. Pound was also committed to the academic profession and to the jurisprudence. In addition, he was sympathetic to the progressive political causes. He sharply criticized common law. Judging, he argued that common law was too individualist in orientation. He advocated legislation to modernize the law. He believed law should be informed by the social sciences, and he advocated an instrumental view of the law. Cotterrell flattens much of this painting found in the end of the reactionary defender of an organic view of the common law, serving the interest of the legal professions. Perhaps a better way to understand Pound is that his political commitment and professional elegancies resulted in a complex and multifaceted set of the view towards the law that differed depending upon the issues and the times. So, I thank you for your time and attention. I look forward to our next session where we will continue to explore the fascinating concept of jurisprudence together. Thank you.